Okay, first of all, under natural justice, there were two principles that were violated: rule against bias and
We're tackling the question whether the court has the jurisdiction to entertain this matter and whether there is still admissibility, whether it has been deemed fit in this court. First of all, I would say no. There is much that has to be said in accordance to Article 45(2). Well, a person has the right to get married to the other person who is of the opposite gender. Why should we still entertain this matter in this court, whereby people are still dating? Let me just say in other words that we're entertaining a matter of homosexuality, of which this court has no matter of entertaining it, it's palpably absurd to continue with this matter in this court. Well, in accordance to Article 165.
Why is it absurd?
Well, I guess this matter is already, as in the case of Cheryl matter versus Century Springs, 1982.
Are unconstitutional and violates the rights of the citizens of the Republic of Chile. My lords, for my lords, section 1, those sections that I have said, they provide on unnatural offenses, attempts, and also indecency offenses. That's a summary of what the section provides, because we all know. So, my lords, what I would like to say is that my counsel from the applicants have said that the gays, or rather the lesbians, are being discriminated on the basis of sex. But here we are not trying to discuss on the sex, the gender, but rather the sexual orientation. And this penal code, was codified and it is ratified to form parts of the laws of Kenya. And so it is constitutional on the grounds that when you go through chapter 4 of the Constitution of Cheneo, it provides on the Bill of Rights, freedoms, and also the limitations. And on these rights, there is the right to freedom of association, which is in Article 36, but Article 24(1), it provides on the limitations, and it expressly states that the law can limit a certain right of freedom depending on the nature of that freedom or right.
For the purpose of record, my name is Mashanga Kirado, counsel appearing for the applicants, together with my co-counsels, Ibrahim Otieno and Fred Nyakeo. I'll be tackling issue number 1 and 4. Ibrahim Otieno will be tackling issue number 2, and Fred Nyakeo will be our clients, having to drink from the bitter cup of being subjected to violation of fundamental rights and freedoms. And you're going to demonstrate that in the proceeding issues, and I'll first start with the issue of jurisdiction of this court. And Article 23 read together with Article 165, this High Court has the jurisdiction to hear matters relating to violation and infringement. I'm tackling issue 4. We have the actions of the Ministry of Interior to intercept the communication by by Andrew San to interrupt or to rather intercept his Twitter account. Under paragraph 15 of the fact sheet, we don't see any reasonable grounds upon which the Ministry of Interior can anchor the argument of intercept.
For the purpose of record, I am Ibrahim Ucheno, representing the applicant site, and I'll be tackling issue number 2 on whether Section 162, Section 163, and Section 165 are unconstitutional. And I'll rely on provisions of the Constitution to buttress my argument. And in the first instance, I'd like to rely on Article 27 about discrimination. It is said in the Indian case of State of Kerala versus the administration of Union of England, it was said that discrimination occurs when people who are naturally falling within a category.
My argument with the two principles of restorative justice, fair hearing and adequate notice. Firstly, we'd like to acknowledge that this matter is an administrative action matter, and according to the Fair Administrative Action Act, Section 4 states that, allow me to read, when administrative action is likely to adversely affect the rights of any person, the administrator shall give the person affected by the decision, firstly, trial and adequate notice of the nature. We can acknowledge that this decision of the committee, it was swiftly implemented. This shows that it was quickly implemented. Thus, our clients do not have a trial and adequate notice of the decision being held against them. Secondly, information and evidence should be relied upon in making the decision of the administrative action. The person being affected should be.
Marco Kenya, appearing for the respondent sites. These are my members. Now I'm going to tackle issue
of the NGO board to register this NGO. This was an issue whereby he refused to reserve the name which was proposed.
Right. So look at that vis-a-vis the right of conscience, right? Because that doctor also has the right to conscience, right? And decide what he can do and what he doesn't want to do. And the American Supreme Court has dealt with that issue severally. I remember there's the issue of that person who refused to prepare a cake for a gay couple, you remember? So that issue has been before the American Supreme Court. And they have tried to delineate between that right to conscience, freedom of conscience, and the right of those gay people. So try and look at that case, see, right? The overlap between that. And then the other thing is on the issue of doctrine of exhaustion. I don't think you've all dealt with it properly. So look at that doctrine of exhaustion. There are many case laws and the exceptions, right? So if I'm the petitioner, I will try as much as possible to persuade the court that I fall within the exceptions, right? If I'm the respondent, I try as much as possible to advance that this court has no jurisdiction pursuant to that, right? And then on the issue of whether we should strike down section 162 to 165 of the penal code, right? So look at the case of Anarita Karemi, and that case is instructive in this regard. The courts have said that you have to be precise the provisions of the constitutions that are contravened. Just that you can't just come and tell us strike down this law, right? So you have to tell us strike it down because it contravenes Article 28. How does it contravene Article 28? It's against the right to dignity and 1, 2, 3. It also contravenes this article. How? You explain in depth how that particular section actually contravenes, right? And in the case of Anarita Karemi, a very famous case, the court said, if you're not precise the constitutional violation, then that petition will be thrown out, right? Just don't come and say, this guy has violated my rights, and you leave it for the court to go and search in the constitution the particular right that has been violated. So you have to cite precisely what article of the constitution has been violated and how that article has actually been violated by that law. So look at that case, and then also look at the other case that has actually done that, the security law cases, right? If you look at the judgment, you see how the court analyzes, right? So it says this is the provision, and then it analyzes the provision of the constitutional that are contravened by that particular provision of law of statute, right? So you have to do that juxtaposition properly so that you bring out the issue of infringement of the constitution. So once we decide, those are issues that whoever will be victorious, make sure those issues are funded.
There are quite a number of factors that we are going to consider. So don't be too sure. You might have done and you might have even emerged the best in terms of score, but there are also other factors that we want to put into consideration. But that aside, there are some things that I've noted. Of course, we have perfected in most of the things, but there are some things that are so imminent that they are done by almost everyone. And I've not said everyone, almost everyone. First, when you are aligning as the first person, you have to introduce yourself, you have to introduce your team, and then you also have to give us the roadmap of what you want to tackle. And because this is a moot court, and you have already been allocated time, you know that you have 20 minutes. Tell the panelists or tell the judges how you want to utilize those minutes. And don't just say it for the sake. There's somebody who said that I think this is how we are going to tackle the time and all that, but not stick to that. So you try to stick to that, because time management is part of scoring. So if you are poor in time and you are best in all these other factors, then you might find yourself, you might not emerge as the best, even if you have been good in all those other issues. So the time that you have been allocated, if it's 20 minutes, you say that you intend to use 5 minutes, and this is how you do with your 5 minutes. Then the other speaker or the other council will also take the other number of minutes and how he's going to utilize the same. And at the same time, you are also supposed to give a persuasive and a well-structured argument grounded on the law. So any argument that you make, you have to support it with the law within the minutes that you have been allocated. The other issues, I think I noted them somewhere. I'll just try to highlight the key ones. If, for example, you have said a certain provisions or a certain provision, like in the penal code, is unconstitutional, what is your prayer? You must tell the court what you want out of that, but don't just leave it open. Then there was also the issue of if, for example, time runs out, you request the court, even if you not continue submitting, you request the court, because there is another counsel who have not submitted, you are praying for the court to give 2 or 1 more minute, reasonable time. Don't ask for 5 minutes or 10 minutes. So reasonable time, so that that other counsel can come in. And if you find that you are the last person, make sure within the few minutes or seconds that will be given, you make the prayers. If you don't make your prayers at that point, then you will not have concluded your submission. So the other thing is, if you are 3 counsels, you are 2. You have finalized the part that you are submitting on. Because I've just noted, there are some firms that have agreed. You go and research on your issue, you come and submit on that. You are supposed to be conversant with all the issues, such that if one person is not going to present because of one reason or the other, you'll be able to fit very fast. And that's the reason why you are finding a situation where after a counsel have been able to submit, as he is sitting, is recalling there is another counsel who is supposed to submit. And is speaking as is going. As you are still on the floor, call upon the other counsel to come and submit. You request the court that you want now the other counsel to come and submit. But don't run away. You are not in a fight, a battleground. Just take your time, and as the person is rising, you are then taking your seat. The other thing is, there have been mention of a number of cases. Some of them are somehow strange, but kindly also not to report the ear, so that even the judge can be able to see the relevancy of that case and whether it might have been overtaken by events. Then the other thing is we are so inclined towards America, Australia, and we are forgetting that before you go to, okay, Australia, I know it's a Commonwealth country, but before you go that far, first of all, try to look at what we have closer home. UK, South Africa. So you look at those cases that are more close before you go far. And if they are not there, then you can be able to borrow some of the decisions made in those other jurisdictions. The other thing, get the facts, understand the issues, know the provision of the law that is applicable, apply the same when you are doing your analysis. It's not all about giving provisions of the Constitution, of the Penal Code and all that without resolving your problem. Then I've not checked these memorials, I've not gone through them, but I've noted a lot of errors. Even editing errors. Like a statute, there is one I saw in the first page, if I'm not wrong. Penal Code, small letters. Those are obvious errors, and they might cost you when you are being awarded. So if you are the person who was doing the memorials, let your team member edit that work, or you edit that work together. You minimize some of those errors. Even the constitutional provisions should be able to minimize some errors I noted on the same.